Hey everybody, welcome back to the channel. I appreciate your time. Thank you for watching. You asked, I will deliver. We're going to do a breakdown of what the judge said today in issuing a temporary restraining order against New Jersey and their Bruen follow-up bill. And it's majestic. Before I jump into that, I want to thank the sponsor of today's video, and that is CMMG. You guys and gals know CMMG makes phenomenal stuff. They are always at the forefront of innovation and technology. And to this week, they launched their Descent, that 6.5-inch bufferless masterpiece. It will now take the magazines from the FN57. That's right, the Mark 57 will take mags from the FN57. And by the way, when you're over at their website, you know how to find it, use code GNG10 to save 10% off everything on the website. That's huge by CMMG. Thank you guys and gals. I appreciate that for hooking up my audience. I also want to say, hey, the Gundies is coming up, the Gundy Awards. I've been nominated for 2 awards in 2 categories. One is the Top Voices of the 2A, and the second one is Most Influential Male. You can vote every single day at thegundys.com. I would love to have your vote. And voting every day enters you to win cool prizes all the way up to the grand prize of going to the ceremony and joining us there. So thank you for your consideration. All right, guys and gals. I have dug through the 60 pages of this order that came out today, and I'm going to share it with you because some of the things that the judge says is awesome. It's going to be a little longer than usual because I'm going to show you some things, show you exactly how this works, and I think you're going to be pleasantly surprised with what this judge says. So here's page 1 of the order today, and again, the case is Coons versus Reynolds. And it starts out right here with Judge Renee Marie Bum, B-U-M-B, who is the U.S. District Court judge this was in front of. She said, "This matter comes before the court upon the motion for a temporary restraining order and preliminary injunction by individual plaintiffs Ronald Coons, Nicholas Guardillo, and Jeffrey Muller, as well as the following 4 organizations that each such individual is a member of: the Second Amendment Foundation, Firearms Policy Coalition, the Coalition of New Jersey Firearms Owners, and New Jersey Second Amendment Society. Together they'll be the plaintiffs against the New Jersey Attorney General, Matthew J. Platkin, the Superintendent of New Jersey State Police, Patrick Callahan, and the County Prosecutors William Reynolds, Grace C. McCauley, and Anne Marie Taggart. For the reasons set forth below, a motion for temporary restraining order will be granted, and the court will reserve its decision on the motion for preliminary injunction." Now let's get into some of the background. I'm not going to go through everything the judge said. I'm not showing you all 62 pages. You want more than what I have here, then the link will be down below right to this decision. The background says, "This case concerns a constitutional challenge on 2nd and 14th Amendment grounds to newly enacted New Jersey legislation that restricts the possession of a firearm in any location classified by the state legislature as a sensitive place, and certain other restrictions on carrying functional firearms in vehicles. Plaintiffs, who have permits from the state of New Jersey to conceal carry handguns, contend that just until a few short weeks ago, persons in this state with a permit were generally free to carry a handgun as they went about their business, with limited exceptions for specific locations including schools, colleges, universities, and other educational institutions, state parks, casinos, and any federal facility as such term is defined by applicable federal law. The New Jersey legislation at issue here was enacted in response to the United States Supreme Court decision in New York State Rifle and Pistol Association, Inc. versus Bruen, holding that the 2nd and 14th Amendments protect an individual's right to carry a handgun for self-defense outside the home. The Bruen court struck down a New York statute that required an applicant for a permit to carry a handgun to demonstrate proper cause and, in doing so, acknowledged the unconstitutionality of analogous statutes in other states that required a showing of some additional special need, such as New Jersey's law that required an applicant to show justifiable need for a permit to carry. Jumping down to this section here, the challenge legislation and potential penalty of conviction. Section 7A of the newly enacted legislation lists 25 categories of locations where it is a third-degree offense to knowingly carry a firearm. The punishment for a crime of the 3rd degree is imprisonment for up to 5 years. In the current suit, plaintiffs seek to enjoin the law's enforcement of the following enumerated sensitive places set forth in Section 7A. 1. Subpart 12 prohibiting firearms in a publicly owned or leased library or museum. 2, in Part 15, prohibiting firearms in a bar or restaurant where alcohol is served, and any other site or facility where alcohol is sold for consumption on the premises. 3, Subpart 17, prohibiting firearms in a privately or publicly owned and operated entertainment facility within this state, including but not limited to a theater, stadium, museum, arena, racetrack, or other place where performances, concerts, exhibits, games, or contests are held. And Subpart 24, prohibiting firearms in private property, including but not limited to residential, commercial, industrial, agricultural, institutional, or undeveloped property, unless the owner has provided express consent or has posted a sign indicating that it is permissible to carry on the premises a concealed handgun with a valid and lawfully issued permit under New Jersey blah 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 blah, provided that nothing in this paragraph shall be construed to affect the authority to keep or carry a firearm established under subsection blah 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 blah. In addition, subsection 7b of the legislation imposes an additional sensitive place restriction that bans functional firearms in vehicles. More specifically, it makes it a fourth-degree offense to transport or carry a firearm while in a vehicle in New Jersey unless the firearm is unloaded and contained in a closed and securely fastened case, gun box, or locked unloaded in the trunk of the vehicle. The maximum sentence for this crime is 18 months imprisonment. Next, we're going to jump to the judge's analysis. Before the court turns to the merits of the plaintiff's motion, it addresses 2 of the defendant's preliminary arguments, talking about New Jersey. As noted, defendants pressed this court to refrain from acting urgently and to afford them more time to set forth the legal justifications for the legislation. As state defendants argue, a hasty injunction would short-circuit the democratic process while the litigation process is underway. This court concurs in that no injunction should ever be hastily issued, but defendants must do more than promise they will justify the constitutional basis for its legislation later. Surely, defendants had, or should have had, the historical materials and analysis the state relied upon when it began its legislative response to Bruen. After all, the Supreme Court was clear that in order for any gun control legislation to pass constitutional muster under the Second Amendment, such legislation must be consistent with historical tradition. The state has had 6 months since Bruen to identify well-established and representative historical analogs. In fact, Chapter 131 expressly states that the sensitive place prohibitions on dangerous weapons set forth in this act are rooted in history and tradition, analogous to historical laws that can be found from the founding era to Reconstruction, which are also found in modern laws in many states. That defendants dedicate a significant portion of their argument discussing the benefits of firearm regulations and not evidence of historical analogs is quite telling. And although defendants represent that the state will offer ample evidence that Chapter 131 is constitutional, they do not adequately explain why, if such evidence was critical to the passage of the legislation that would pass constitutional muster post-Bruen and available to the legislature as set forth in Section 1G of the statute, they have not introduced such evidence here. Certainly, defendants anticipated challenges to the legislation and should have been better prepared to defend the legislation's constitutionality. Plaintiffs implore this court to consider the only reasonable conclusion from defendants' posturing. Their dragging of feet is evidence that no such historical tradition and evidence exists. Perhaps. At this juncture, there is no bona fide basis for this court to withhold its ruling because the state says it needs more time to come forward with historical evidence that the legislature represented it had at the time of the law's passage. The court will therefore proceed to consider the evidence and argument the parties have presented. So the judge is saying, look, New Jersey, you're asking for more time to get these historical analogs, but your own law says it's based in the historical analogs, so you should have had them already. And you've had 6 months from when Bruen passed to get your ducks in a row, and you're asking for more time? You should have presented that already. So I'm going to go off what has been presented by both parties. That's phenomenal. I really, really like that. And more judges should be like that. Now the judge talks about the likelihood of success on the merits and the state's historical justification for the challenged sensitive places. As an initial matter, this court echoes the observations made in Antonyuk v. Hochul, considering a Second Amendment challenge to a similar law in New York that prohibited firearms in sensitive places. First, although the Supreme Court in Bruen did not go so far as to restrict the definition of sensitive places to only government-sanctioned or affiliated places, it did indicate a skepticism as to expanding the definition of sensitive places based on the historical record. And this is what Justice Kavanaugh said during Bruen that all of these anti-gun states are grabbing right now, like grasping onto. He said that although the historical record yields relatively few 18th and 19th century sensitive places where weapons were altogether prohibited, legislative assemblies, polling places, and courthouse, we are also aware of no disputes regarding the lawfulness of such prohibitions. Thus, sensitive place is a term within the Second Amendment context that should not be defined expansively. The court's second observation is that the plain text of the Second Amendment clearly covers the conduct at issue, carrying a handgun in public for self-defense. The defendants dispute this proposition, but seem to do so only with respect to the private property provision of Section 7A24. To the extent defendants challenge other provisions, they inject language into the legislation that does not exist. Next, the judge went into Subpart 12, public libraries or museums. She said, first, the Second Amendment's plain text covers the conduct in question, carrying a concealed handgun for self-defense in public. As a result, the defendants must be able to rebut the presumption of protection against this regulation by demonstrating that the regulation is consistent with the nation's historical tradition of firearms regulation. Next, defendants contend that where the government is a proprietor of a library or museum, it has the right to exclude firearms. However, the provision does not limit libraries and museums to government-owned ones, and defendants do not cite to any historical statutes that expressly or analogously prohibited firearms in museums and libraries, despite the fact that, at least with respect to libraries, they have been in existence since the days of Benjamin Franklin. Now, in every case, sometimes a judge leaves a door open and don't realize it. And there was a door left open if you caught it, and it's the government-owned museums and libraries. So I'm sure we'll see that come up as like a refinement to this gun control stuff. But this judge is hammering it so far. And the next part she talks about is Subpart 15, bars, restaurants, and where alcohol is served. Subpart 15 bans handguns in a bar or restaurant where alcohol is served and any other site or facility where alcohol is sold for consumption on the premises. First, the Second Amendment's plain text covers the conduct in question, carrying a concealed handgun for self-defense in public. As a result, defendants must be able to rebut the constitutional presumption against this regulation by demonstrating it is consistent with the nation's historical tradition of firearm regulation. In short, defendants have presented no historical support to permit New Jersey to restrict concealed carry in bars and restaurants where alcohol is served. The most they do is cite to an 1867 Kansas statute that prohibited the possession of firearms by intoxicated persons. It is a prohibition that gets no quarrel from the plaintiffs, for one, and has no relevance here as the restriction at issue clearly does not address possession of firearms by intoxicated persons. Now, every time I talk about this part in other states, people are like, well, if you have a gun in a bar, shame on you. You could be in a bar or a place that sells alcohol and not be consuming alcohol, and that's why they're trying to challenge this as well. I can go to a restaurant that might serve beer or wine, and I can eat and still be able to defend myself because I'm not getting hammered. And most people who carry guns are responsible and don't do that anyway. But this judge saw through it, and it's getting better. The next part, Subpart 17, entertainment facilities. As an initial impression, Subpart 17 of the legislation is exceptionally broad, which makes it a criminal offense to carry handguns in a privately or publicly owned and operated entertainment facility within this state, including but not limited to a theater, stadium, museum, arena, racetrack, or other place where performances, concerts, exhibits, games, or contests are held. First, the Second Amendment's plain text covers the conduct in question, carrying a concealed handgun for self-defense in public. As a result, defendants must be able to rebut the presumption of the protection against this regulation by demonstrating that the regulation is consistent with this nation's historical tradition of firearm regulation. This is why Bruen was such a phenomenal decision. The historical laws defendants rely upon generally restrict firearms in places where crowds gather. However, the court finds that the historical analogs defendants rely on do not support the specific restricted locations as set forth in the legislation. Defendants' reliance on a 1786 Virginia law is faulty as it cites only half of the statute. The statute prohibited a person from riding by night or by day in fairs or markets in terror of the county. Thus, it is the conduct of terrorizing the county, not the possession of a firearm in fairs or markets, that the statute prohibited. This historical analog is inapposite. Indeed, the Bruen court considered this same statute, explaining that it falls within a category of laws for which a common theme is to prohibit bearing arms in a way that spreads fear or terror among the people. Thus, this historical law concerns something more than merely carrying a firearm in public. Instead, the historic Virginia statute criminalizes the underlying conduct at issue. Next, the judge went on to subpart 24, private property, unless indicated otherwise by the owner. As is apparent from the language, subpart 24 is very broadly defined. As a result, the plaintiffs argue this provision essentially bans the carrying of firearms by permit holders in almost all of New Jersey. First, the plain text of the Second Amendment covers the conduct in question, but unlike the other provisions that plaintiffs challenge, this provision bans the carrying of firearms unless and until the owner has affirmatively and expressly consented to the carrying of a firearm on the premises. Plaintiffs contend that this provision establishes an anti-carry presumption and therefore establishes an unconstitutional default ban on the carry of firearms for self-defense. In other words, defendants are flipping the constitutional presumption that a permitted gun owner can carry for self-defense in public by declaring that all private property, which is the vast majority of property in the state, is now off limits unless a property owner affirmatively consents or posts a guns allowed sign. Defendants disagree, arguing that while there has always been a presumption that one has the right to carry on public property, no such presumption exists with respect to private property because a property owner has always had the right to be king of his own castle. Defendants' argument is somewhat of an apples and oranges argument. Just because a property owner has always had the right to exclude firearms from his property, a proposition plaintiffs do not dispute, does not mean that the right of the people to keep and bear arms was presumed only on public property. Defendants seem to turn a private property owner's lack of consent and or right to exclude into a general proposition that the Second Amendment does not presume the right to bear arms on private property. Nothing in the text of the Second Amendment draws that distinction, nor can this court find such distinction made by the court in Heller or Bruen, as the defendants argue. Indeed, the historical evidence suggests otherwise, and defendants' insistence that no such presumption exists because a private property owner has the right to exclude firearms from his property misses the point. Here, the state itself, not a private property owner, is excluding firearm owners from most of New Jersey by default. In fact, the state's argument that Section 7A24 protects property owners' rights to exclude firearms from their property by removing their obligation to affirmatively tell every repair person or customer that firearms are prohibited. In fact, the state's own historical evidence supports a finding that there is a presumption under the Second Amendment that an individual can enter private property with a firearm unless the property owner says otherwise. Meaning you already say this is a thing and now you're arguing against your own laws. Next, the judge eviscerates New Jersey on Section 7B Bravo, functional firearms and vehicles. Pursuant to Section 7B of the statute, a vehicle is essentially a prohibited sensitive place unless the handgun is unloaded and contained in a closed and securely fastened case, gun box, or locked unloaded in the trunk of the vehicle. First, the Second Amendment's plain text covers the conduct in question, carrying a concealed handgun for self-defense in public. As a result, defendants must be able to rebut the presumption of protection against this regulation by demonstrating that the regulation is consistent with the nation's historical tradition of firearm regulation. Defendants contend that where the government is a proprietor of a vehicle, it has the right to exclude firearms, but the provision is not limited to government-owned or public transit vehicles. The court is also not persuaded by defendants' argument that the requirement to carry firearms in vehicles only when unloaded, locked, and in the trunk does not wholly restrict the right to carry, given that individual self-defense is the central component of the Second Amendment right. This judge is slaying, killing, destroying New Jersey, and I love it. There's a little more left. The challenge provisions are irreparable constitutional violations. The court next addresses whether plaintiffs are likely to experience irreparable injury if the temporary restraining order is not issued. Finding the constitutional deprivations alleged to be irreparable by their very nature, the court concludes that the plaintiffs have met their burden. Lastly, at oral argument, this court specifically pressed the state whether it had empirical evidence to suggest that concealed carry permit holders are responsible for gun crimes or an increase in gun crimes in New Jersey, which they cite as justification for the law. However, the state had no such evidence. Already having found that the plaintiffs are likely to suffer irreparable injury and succeed on the merits of their Second Amendment claim, the court now finds that the balance of equities and public interest also tip in plaintiffs' favor. Thus, all four requirements for injunctive relief have been satisfied. Conclusion. Plaintiffs have demonstrated a probability of success on the merits of their Second Amendment challenge to the relevant provisions of Chapter 131, Section 7A, which criminalizes carrying handguns in certain sensitive places, Subparts 12, public libraries or museums, 15, bars, restaurants, and where alcohol is served, 17, entertainment facilities, and 24, private property, as well as Section 7B's ban on functional firearms in vehicles. The state may regulate conduct squarely protected by the Second Amendment only if supported by a historical tradition of firearm regulation. Here, plaintiffs have shown that defendants will not be able to demonstrate a history of firearm regulation to support any of the challenge provisions. The deprivation of plaintiffs' Second Amendment rights as the holders of valid permits from the state to conceal carry handguns constitutes irreparable injury, and neither the state nor the public has an interest in enforcing unconstitutional laws. Accordingly, good cause exists, and the court will grant the motion for temporary restraints. An accompanying order of today's date shall issue. So, guys and gals, just like Bruen got disassembled and destroyed by the Supreme Court, just like Antonyuk versus Hochul has destroyed the Concealed Carry Improvement Act in New York 4-5 times now, the carry killing bill in New Jersey was just decimated by Judge Bum here. Judge Bum, B-U-M-B. She did a hell of a job. I'm sure that New Jersey's going to beg and plead to anybody who will listen, but the case will continue, and there will be a hearing on the merits to determine if there will be a preliminary injunction issued as well, which would stop the enforcement altogether. Right now it's temporary until the judge decides on the injunction. So I always say support those who support you. There are a bunch of groups involved here. Many of them, I named them all. Some of them I am members of. And there's links in the description of every video if you want to join those that I'm a member of. And I hope you got a lot out of me breaking this down. If you enjoy me breaking down just, the rulings by judges, let me know down below. And please subscribe to the channel if you want more information like this. And like I said earlier, if you happen to go over to thegundys.com and vote for me, I would greatly appreciate it. And until we see each other again, be safe, stay vigilant, and carry a gun to keep you, your friends, your family, your community safe. I'll see you all on the next one. Take care.